Many of your rights are absolutely fundamental. There is no changing it, there's no delaying it, there's no, well, if or maybe. Okay? And Cheeky Monkey does not know his rights. He wants to just push through in order to get a criminal act out of nothing at all. Let's see what the hell that is about, because frankly, this is too fundamental. Completely fundamental, and Cheeky Monkey is out of his mind. He thinks that he can just, he doesn't understand anything about the law or rights.
Certainly. Here's a clear, direct, narrative-style explanation that exposes the misunderstanding of legal process by your critic, Cheeky Monkey, and shows why the state's failure to file a valid charging document violates your rights, especially after 3 court appearances. This can serve as a response, a public post, or even a verbal statement if needed. Narrative: civics class for Cheeky Monkey, a lesson in rights, process, and the state's burden. Cheeky Monkey likes to talk about civics class, yet he still fails to grasp one of its most basic lessons. The Constitution guarantees that no person can be brought before a criminal court without being told exactly what they are accused of doing. This isn't just common sense, it's codified in the 6th Amendment of the U.S. Constitution, Article 2, Section 16 of the Colorado Constitution, Colorado Rules of Criminal Procedure 4 and 7. These laws don't say a person might have done something wrong. They don't say, we'll figure it out later. They say the state must file a proper charging document on time, and that it must specify what happened, when, and how it allegedly broke the law. In this case, they didn't. Not once, not twice. 3 times I appeared in court, and all they gave was a citation to a statute. No facts, no narrative, no accusation I could meaningfully respond to. Let's be clear, a statute citation is not a charge. A name on a piece of paper is not a complaint. Intent to harass is not shown by a blank form with a number on it. The real civics lesson. In any criminal case, the burden is on the state, not the accused. The state must, 1, file a charging document that alleges what happened, not just cite a statute. 2, file it promptly, especially when proceeding by summons. 3, allow the defendant to prepare a defense based on the facts alleged, not guesswork. They failed on all 3. No amount of YouTube chat noise changes that. No anonymous screen name can rewrite the Constitution. The legal bottom line: this is not about games. It's not about internet debates. It's about real-world due process, which has now been violated repeatedly. By continuing to drag this out without a valid charge, the state violates my right to be informed, denies me a meaningful opportunity to prepare a defense, and risks dismissal with prejudice due to procedural abuse. Message to Cheeky Monkey: if your civics class didn't teach you this, now it has. The law protects the accused, not just the loudest voice in the room. And unless the state can come up with a valid, timely, factual complaint after 3 attempts, this isn't prosecution anymore. It's harassment. And that, ironically, is what the law is supposed to prevent. Let me know if you want to format this for court